Major breaking news, huge Second Amendment win today out of the United States Court of Appeals for the Third Circuit, concluding that 18 to 20-year-olds have a right to carry guns and have Second Amendment rights like all other American adults. Major win, another methodological win. In all respects, this is another huge brick in the wall that will help us expand and continue to protect our right to keep and bear arms. Stay tuned, we're going to break it down in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundies Awards for top YouTubers and social media Second Amendment people, one in the top male influencer in the Second Amendment space, in the other category, top voices of the Second Amendment. Proud to be in both categories and a finalist in each. All right, folks, major breaking news, the United States Court of Appeals for the Third Circuit out of Philadelphia and New Jersey and Delaware has issued a major decision stating that 18 to 20-year-olds have full Second Amendment rights, including the right to carry guns, on par with all other American adults. This is a huge win. This is a 2-1 victory. Judge Jordan and Judge Smith, 2 George W. Bush appointees, were in the majority, and Judge Restrepo, a Obama appointee, was dissenting, so it was 2-1. Judge Jordan wrote the majority opinion, and Judge Restrepo again wrote the dissent. The name of this case is Laura and Second Amendment Foundation and Firearms Policy Coalition et al. Against the state police for Pennsylvania. This is a major win. Congratulations to the Second Amendment Foundation and the Firearms Policy Coalition. Now, this decision is very powerful from a methodological point of view. Remember how I explained to you every case and every win, no matter how big or small it is another brick in the wall to protect our rights? This is a huge win because this is the U.S. Court of Appeals. This is a major court just one step below the U.S. Supreme Court. And as I've been predicting, in the term of 2024 and 2025, I believe the U.S. Supreme Court is going to hear an 18 to 20-year-old case. This is very good because it going to allow them to resolve various things, including which is the relevant time period for interpreting the Second Amendment, which is clearly 1791 based upon all the evidence and historical research I put together in my article in the Harvard Journal of Law and Public Policy about a year ago. I'll put a link to it down below. Clearly 1791. And I'm happy to report in this decision here, this says that 18 to 20-year-olds have a right to carry guns and have a concealed carry permit. The good news is they said that 1791, meaning the founding era, is clearly the right place to look for historical analogs, and because the government could not come forth with any historical analog gun control laws that related to 18 to 20-year-olds being barred from carrying guns or having guns. In fact, the evidence at the time period is just the opposite. As you know, we've talked about this before, because the Second Amendment was adopted in 1791. And you know, we've talked about this before, what happened in 1792. In 1792, the Congress enacted the Militia Act of 1792 that said that 18 to 45-year-old men had to bring their own weapons, that's right, their very own weapons, their own ammunition, their own cartridge boxes, and so on, with them to militia musters, which obviously shows that 18 and 19 and 20-year-olds were part of the people that had a right to keep and bear arms, because otherwise how would those 18, 19, and 20-year-olds be able to procure firearms and other weapons in order to bring it to their militia musters? And again, these were privately acquired guns that had to be brought to militia musters. It wasn't given to them by the militias. So the court here, the Third Circuit, analyzed all this and said, first and foremost, undeniably, that if you look at the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. The people include all Americans. This is a critical point I keep hammering home because people keep making this mistake. But it's a very easy win for the Second Amendment community, and you don't want to make a mistake on this easy point, which is this. If you look at how the Supreme Court defines the word people in the Constitution, because the word people appears not just in the Second Amendment, it also appears in the Fourth Amendment, and I think it's also in the First Amendment. The point is, it's in all these different parts of the Constitution. And if you look at how the Supreme Court defines it, it defines the people as all of American citizens, all Americans of all ages and all shapes and all walks and all stripes of life, all of the above, okay? All of that are the people. All American citizens are part of the people. It is a textual matter. So textually, 18 to 20-year-olds are clearly part of the people, as in the right of the people to keep and bear arms shall not be infringed. So because the lawsuit was brought by 18 to 20-year-olds that were denied the ability to carry guns in a very unique set of circumstances I'll describe in 1 second, they are clearly part of the people because they were all American citizens. And once they're American citizens, they are part of the people. Once they're part of the people, and you have a modern-day gun control law that implicates their right of the people to keep and bear arms, those individuals have the right to sue to vindicate their Second Amendment rights, which is exactly what happened here. And you know what happens when a modern-day gun control law touches fingers with the text of the Second Amendment? You know what happens. The presumption is that that modern-day gun control law is unconstitutional and may not be enforced. That is the presumption. No different than the presumption that you are innocent when you go into court, in criminal court, and the presumption is you're innocent and the government has the burden of proof to show that you committed a crime. So too, once the modern-day gun control law touches fingers with the text of the Second Amendment in any respect, the presumption is that modern-day gun control law is unconstitutional. And the only saving way, the only way the government can save that case or save that gun control law is to come forth with historical analog laws from the 1791 founding era, and to show that that has been the law ever since then, that the founding fathers would appreciate and understand that these laws were perfectly acceptable, and they have to be proven not by some airy-fairy generalized historian just telling stories. It has to be these are the laws on the books in 1791 that were enforced that somehow restricted the right to keep and bear arms. And there are very, very few of those. In fact, this court here specifically said that the government failed to come up with a single historical analog laws that would suggest at the time of the founding 18 to 20-year-olds could not carry guns. In fact, all of the laws that the government came forth with in this particular case were, of course, as I predicted, which is why I wrote the big article in the Harvard Journal of Law and Public Policy to get everyone squared away on this, that all they did was talk about mid to late 19th century law, which is far too late. Because remember, James Madison, the last founding father that is alive, dies in 1836, which means that after 1836, there's no more members of the founding generation alive. So what on earth can people living 20, 30, 50 years after that date have any knowledge of what the public understanding was, the public meaning, the public purpose of the adoption of the Bill of Rights? That time period, it's just too late. Everyone is dead. So that's why you have to look at the history at the time of the founding, when the founding generation was alive, and you try to understand, just like any other contract, what did the people who entered into the contract mean when they wrote down those words? What did the words mean to those people? And what did the actions of those people mean to suggest what was the terms of the contract? You don't look at what happens 100 years after the fact, which is what the anti-gunners want to do. And I explained this right off the start, right after the Bruin decision was issued. I said this is exactly where the anti-gunners are going to go, because there's a lot more gun control laws in the late 19th century for various reasons, not least of which is there's a movement among certain states to try to punish the former Confederate soldiers, and a movement to have gun control laws to apply them to the freed African-American slaves, which is why you see much more gun control law in the late 19th century after the Civil War than at the time of the founding, which is exactly why the anti-gun lobby wants to talk all about the historical analog laws after the Civil War, because there's a lot more of them, makes their job a lot easier to meet their burden of upholding modern-day gun control laws. Now, just as a point of clarification, what this case is about factually is kind of interesting. So under Pennsylvania law, 18 to 20-year-olds are not allowed to get a concealed carry license. However, they're allowed to open carry. Hear what I just said? Under Pennsylvania law, according to this decision, which I'll put a link to down below, 18 to 20-year-olds were not allowed to get a concealed carry permit, but they could open carry. So what's the problem? Here's the interesting problem. There's an exception to that. In the event that Pennsylvania declares a public emergency, whether it be COVID or a hurricane or a tornado, whatever it is, if they declare a public emergency, then no one is allowed to open carry. So the result of that is, in the event that Pennsylvania declares an emergency, then 18 to 20-year-olds are not allowed to conceal carry because they're not allowed to under the law of the statutory law, and they can't open carry because, of course, in a time of a public emergency, no one is allowed to open carry under Pennsylvania law in those times. So here, these individuals sued, saying that there was a series of public emergencies where they could not carry, including the COVID emergency, and they were barred from carrying, and they wanted to carry for protection. So they sued, and the court said, indeed, that is a violation of the Second Amendment. You have to allow people the right to carry guns, and 18 to 20-year-olds are not allowed to carry guns in those times. And then the state came back and says, well, this case is moot, and this is kind of interesting. They said this case is moot because obviously there's no public emergency right now. They can carry right now. 18 to 20-year-olds can carry today. And the court said, we reject that on the grounds that, yes, it may be a moot case technically speaking today, but because this controversy is capable of repetition in the future, they concluded that one of the exceptions to the mootness doctrine applies, and as a result, they went ahead and said that the plaintiffs had standing and the case was a live case in controversy, and they decided it. Keep in mind that the notion of a case that is moot but is capable of repeating itself is a long-standing rule that is an exception to the mootness doctrine. Keep in mind, under the Article 3 of the U.S. Constitution, a case has to be an active live case or controversy for a court to have federal jurisdiction. If the case is moot, meaning the controversy has resolved itself, it's technically not a case or controversy. But there's an exception to that where, again, the case is capable of repetition. The classic example is the abortion cases where a woman, obviously every 9 months, a woman suing involving an abortion case, every single 9 months, that case is obviously going to be mooted out. But the courts say, well, yes, it is mooted out in one sense, but the exception, which is this controversy is capable of coming up over and over and over again, and therefore it's an exception. And that's exactly what this court said here. They said that this issue, because Pennsylvania repeatedly declares public emergencies all the time, essentially, so therefore this is going to keep coming up. We're going to resolve it right here, right now, and that's exactly what they did. Powerful decision that says 18 to 20-year-olds have a right to keep and bear arms, and that is excellent news for us. I should also say there's a lot of information here. I'll try to put a link to it down below on X or somewhere else, maybe do a separate video. There's a lot of information you'll find in this opinion that we've talked about on this channel. You will find, if you are a Four Boxes Diner geek out there and you've been tracking this information and you write down what I say and you track what I say, you're going to find a lot of similarities to what you already know as the smartest person in the room and what the Federal Court of Appeals and the Third Circuit says. So again, I will make you as smart as judges on the Third Circuit Court of Appeals and in all the courts of appeals across this country, including the Supreme Court, if I have my goals and I succeed. And this is going to be further vindication that indeed, if you follow the Four Boxes Diner Second Amendment channel, you will be the smartest person in the room. And maybe not as smart as a Third Circuit Court of Appeals judge, but you're going to get close. And when you read this opinion, you will see what I'm saying. So, all right, folks, there you have it. I hope you enjoyed the show. Make sure you follow me on X at Four Boxes Diner and subscribe and resubscribe. We keep getting people knocked off the channel for some reason, so keep subscribing and resubscribing, and we will see you again soon, very soon, here at the Four Boxes Diner.
Orders up. Table 2A.